Okay, we're gonna get this session started since we're all dealing with a close on time. The last session seemed to run a little bit over, and hopefully we'll get this one done in the next hour and a half so we can all get off to lunch. I want to remind everyone that this seminar does qualify for CLE credits. If you're an attorney and you want credits, you need to sign in on the sign-in sheet in the back of the room. And also at the back of the room, there is a certificate form that you can take with you and record however many hours you think you deserve for CLE credit for this. The topic today is local issues that have been before the Supreme Court. I ask everybody to turn off their cell phones. The handouts that will be used in this presentation are available on our website and our mobile app. So please get those if you're interested. The past Supreme Court term was one of the most important for local jurisdictions. A lot of the cases that included things like internet sales tax case, the travel ban, and a number of First Amendment free speech and Fourth Amendment search cases all impact us as local governments. And we're honored to have our speaker today, Lisa Sordin, who is going to come to us and bring us up to date on what's happened with the Supreme Court. She is the Executive Director for the State and Local Legal Center. So with that, Lisa.
Thank you. So, Arizonans, it's great to be here at the Phoenician. For those of you who are familiar with DC real estate, I was telling Christine that my balcony is bigger than both of the bathrooms in my house. But not bigger than them combined. So I guess I'll stay in DC and not move out to Arizona. So how many of you have heard of the State and Local Legal Center? All right, I was hoping for 3 hands, and I think I got 2. So that's actually pretty good. So the State and Local Legal Center files amicus curiae, which means friend of the court, briefs to the Supreme Court in cases affecting state and local government on behalf of what calls itself the Big Seven, national organizations that represent state and local government officials. So my clients essentially are the National League of Cities, the U.S. Conference of Mayors, the National Association of Counties, the National Governors Association, and the National Conference of State Legislatures, and a few other groups that I can never remember if I'm really put under pressure of having to name them all. So what they do is they combine forces and they file these briefs in the Supreme Court. And what the briefs do is they talk about what will be the impact of a particular Supreme Court case on all cities, not just the city that happens to be the party in the case, but all cities throughout the United States. So that's what the SLLC does. It's existed since 1983, and it was started because a couple of Supreme Court justices said publicly that state and local governments were losing cases because they were poorly represented before the Supreme Court. So, like I said, my organization exists to be a voice about everything that state and local government every way that they're affected in Supreme Court cases. So this is what I'm going to talk about today. I'm going to give you some general observations on this last Supreme Court term. I'm going to look in depth at a couple of cases affecting local government, and I'm going to talk about Justice Kennedy and his significance and Judge Kavanaugh, who I'm probably going to end up calling Justice Kavanaugh, but you'll forgive me. And then I'm going to talk about a couple of cases of interest to Arizona cities that have been accepted for next term. So this last Supreme Court term, as the introduction said, was a really big one for the Supreme Court. A lot of big cases were decided, and a lot of big questions were left unanswered. It was also the first term for one justice, first complete term for Justice Gorsuch, and for Justice Kennedy, it was his last term. So here is the Supreme Court that we had until about a month ago. And you'll see we had 5 conservative justices and 4 liberal justices, with a star next to Justice Kennedy. The star is because Justice Kennedy wasn't a reliable conservative. He tended to be more liberal, especially as time went on, in more of the social justice, social policy kind of issues. But in general, he was a conservative, and last term, he very much proved to be a conservative. So last term, the court decided 72 cases. That's about typical. 30 years ago, they were deciding twice that many cases. The cases were closer this term than usual. Typically, only about 5-4 of the cases are about 20% of cases are 5-4. That may surprise you. And the reason why it surprises you is the only time your average American hears about the Supreme Court is at the end of June. Because at the end of June, all the big cases come out. And those for the last 20, 25 years have been generally 5-4. But it's very unusual in a way for the court to have 5-4 cases. Like I said, only 20% of the docket is typically 5-4. This term we had almost 30% of the cases 5-4, and I'll talk more about why. And even more startling, I think, is the fact that about 50% of the Supreme Court cases are actually 9-0. 50% are 9-0. That's because they're so boring that, of course, all the justices would agree about them. We're not going to talk about a lot of 9-0 cases here. So, as I said, in general, we have had a conservative Supreme Court, but with Justice Kennedy sort of in the middle as a swing justice, this time, remarkably, he sided with the right-leaning justices every single time in 5-4 cases. Think about that in contrast to terms more recently, where we had him in 5-4 majorities in the same-sex marriage case, or in the defense of marriage case, or in one of the health care cases, or an affirmative action case, in an abortion case, all in the last 3 or 4 years, siding with the liberals. Here, in this last term, we see him siding with the conservatives, and that really affected how a lot of the cases turned out. And the court has accepted about 40 cases for next term, which is about typical. Justice Thomas writes the most opinions on the court. I try to avoid reading any of them. I'm never successful. I always have to read at least a couple. This is because he writes a lot of concurring and dissenting opinions. Justice Sotomayor is well known to be very outspoken on the court, much to the annoyance of the Chief Justice. She'll frequently, in tense cases, ask like a nail-biting question at the last minute, only to have the Chief Justice not quite roll his eyes, but cut her off and become visibly impatient with her, despite the fact that he is a very calm and seemingly nice man in general. Justice Sotomayor and Justice Ginsburg agreed the most. Alito and Sotomayor disagreed the most, which it surprises me that Thomas isn't in that calculus, but it's probably just a matter of degrees with these justices. What you might find most interesting about this term, I think what I found most interesting was this. It was Justice Roberts in the majority more than any other justice, not Justice Kennedy. That is a sign of things to come. But Roberts was in the majority in some non-controversial cases, which I think kind of explains why he was in the majority more than Kennedy. But typically, because Kennedy's a swing justice, he's in the majority the most. So, as I said, a sign of future things to come is Justice Roberts is going to become our Chief Justice and our swing justice, probably in about a month. In my lifetime, and in any time that I can think of the modern Supreme Court, we have never had the Chief Justice as also the swing justice. That wasn't true in the Warren Court, wasn't true in the Berger Court, wasn't true in the Rehnquist Court, it hasn't been true in the Roberts Court. And that maybe doesn't make that much difference, except that, because the Chief Justice in theory doesn't really have that much more power than any of the other justices. The one thing that he can do is he can assign the writer of cases in the majority, and that can sometimes mean that majority cases fall apart if someone writes an opinion the way a colleague doesn't like. So that's where the Chief Justice has some more power. And importantly, a lot of people believe that the Justice, sort of Chief Justice Roberts, saved the Affordable Care Act because he was worried about the court looking too political. And I think part of the reason why he did that, if he really did it for that reason, is because as Chief Justice, I think he has special concerns about the integrity of the court. So we may see Chief Justice Roberts be a little more liberal in time, or we may not. Only time will tell. I think in the big controversial cases, it's going to be a stretch for him, but I think we're going to see some more nuances in him over time. Because it's important to emphasize, in this term, he only voted with the liberals 3 times in close cases. So the idea that he is going to be the new swing justice, he's not going to be doing all that much swinging, is what I'm trying to say. So in terms of local government, in terms of the statistics about the court, so there were 6 cases this term that involved local governments as a party. But that's kind of a red herring, because there can be lots of cases that affect local governments where they just don't happen to be a named party. And in fact, on the flip side, there were 2 cases involving local governments that were removed from the docket, and one of them actually came from Arizona. It was the Salt River Project case. It had to do with the state action doctrine, which is very esoteric, and I won't discuss it any more than to say that it was on the court's docket and removed. So even though there were only 6 cases where the local governments were a named party, remember it's 6 out of like 70, and remember there's a lot more cases that impact local governments that where local government isn't a named party. What was sort of unique about this term is the court took 8 First Amendment cases, which is a lot of cases on the First Amendment. And remember, this is a a court that, like no other court maybe in history, has loved a broad interpretation of the First Amendment, thinks everything is speech protected by the First Amendment. So for them to take 8 cases is a big deal. And remember, most of those cases are not going to go the way of local government. And then the court took a lot of bread and butter cases for local governments, a lot of the regular cases, takings cases, employment cases. But those are going to be largely ignored by my presentation because there's so many big cases that are more interesting and exciting to talk about. But just a little second on some of those bread and butter cases. The court had 4 Fourth Amendment cases, which is about typical. One was a false arrest case. 3 were search cases. The most prominent one was, of course, the guy with the cell site location data. This is when your cell phone, now if you just sit here, your cell phone is pinging towers constantly, that information goes to your cell phone company. Can you search that information as a police officer without a warrant? The court said no. That was by far the biggest and most significant Fourth Amendment case. Then there were 3 more routine First Amendment cases. These aren't the big, exciting travel ban kind of cases. There was a retaliatory arrest case, a case involving banning political apparel at polling places, and a case involving government-mandated disclosures. All of these cases were losers for state and local governments. Unsurprising. Almost all routine First Amendment cases are losers for local governments, so I wasn't surprised or upset or disappointed by those losses. And then there were 3 qualified immunity cases. So qualified immunity is the doctrine that protects local government local government officials for being sued for constitutional violations. Even though this is a very small part of the law, the court's going to take 3 to 5 of these cases a term, and it sort of had a healthy appetite for qualified immunity last term as well. So now I'm going to move on and talk about the big cases for the Supreme Court's term, particularly the ones that will impact you in Arizona. So the first one is my baby, South Dakota versus Wayfair. I think of it as my 3rd child. Don't tell my other children. But, you know, everyone's got to have a pet project, I guess. So in this case, this made the news. This is a big deal. And maybe if some of you have already received some revenue in your jurisdictions, probably not. But you've at least had to pay the taxes online if you've been shopping online. The Supreme Court held in a 5-4 decision that states and local governments can require out-of-state retailers to collect sales and use tax. This is a really big deal. This case is worth between $8 and $33 billion a year. And you might say, Lisa, that's really a crazy range. $8 and $33 billion. I mean, is it 8 or is it 33? Well, no one really knows. We're not going to know until the collections all come in, but it's worth a lot of money every year. And what the court said was basically the Wayfairs of the world that have that don't have warehouses in all 50 states but are selling in all 50 states, as long as they have an economic and virtual context with the state, they can be required to collect sales tax. So this case has a very long history. And without going through all the details with you, in 1967 and again in 1992, the Supreme Court had said, look, if a vendor doesn't have a physical presence in the state, they can't be required to collect sales tax. This wasn't such a big deal in 67, wasn't even that big of a deal in 1992, because remember, Al Gore had not yet invented the internet. But then, there's a clip, I've seen it a couple times, I think it comes out of like 1994, where it was like on Good Morning America, where you have a TV anchor first talking about the internet. So it's about 2 years later. So what's happened was we had Amazon and all these other companies that didn't have warehouses all throughout the United States selling products and not collecting sales tax. And what I should tell you about Wayfair that you might find really interesting is that until South Dakota pointed this out in its brief in this case, Wayfair advertised on its website, shop at Wayfair, you don't have to pay sales tax, which is of course incorrect. You still have to pay the sales tax. It's just that Wayfair wasn't going to collect the sales tax. Needless to say, after South Dakota pointed that out in their brief, that was taken off of their website. So the story of how this case got to the Supreme Court is an interesting one, and it involves my organization. So I'll tell you a little bit about it. The long and the short of it is that a lot of states were really annoyed by that Quill rule. It's a rule from 1992 that had said, you know, if you're an out-of-state retailer, you don't have to collect sales tax. And a lot of states were annoyed by it, and Colorado had passed a law saying basically if you're not a state vendor and you sell someone $500 worth of goods, you have to send a notice to that person. And the same notice goes to the Department of Revenue. Why? So that people will pay the tax on their own. So people challenged this law and said this law violates Quill. But you think about it, that doesn't really make a lot of sense. You're not requiring the retailer to collect tax. you're requiring the retailer to send a notice. Anyway, the case went to the United States Supreme Court, but over a very odd sort of issue. The issue is whether or not the challenge should be heard in federal or state court. So my organization, the State and Local Legal Center, filed an amicus brief saying, well, we think the case should be heard in state court, but what we really think the court should do is overturn this 1992 rule that says state and local governments can't require out-of-state retailers to collect sales tax. And much to my surprise, and the surprise of many other people, Justice Kennedy wrote a concurring opinion saying, I think we should reconsider this rule. This was in 2014 or 2015, I think it was 2015. And it was a surprise to everyone because, of course, that wasn't the legal issue in the case, but that was exactly what we asked for in our brief. So what we needed was a state, essentially, to pass a law that violated the Quill Doctrine that could then go to the Supreme Court. So South Dakota stood up and did that and said, if you do $100,000 worth of sales in our state or 200 transactions, we're collecting. We don't care how many warehouses you have or you don't have. You're collecting. But the whole point of the law was for it to go to the United States Supreme Court, which is what happened. So the oral argument was a very tense experience for me because it really didn't go the way I thought it was going to go. We knew we probably had 3 votes on the court, and remember, you only need 5 to win. So the 3 votes we knew we had were Justice Kennedy, of course, Justice Thomas, because he had said, he had been on the court in 1992 and had affirmed the Quill rule, but he said in 2003, sort of like Santa Claus, I no longer believe in the Dormant Commerce Clause. So I essentially don't believe in this legal doctrine anymore. So we knew we had his vote. And Justice Gorsuch, when the Colorado case went back to the 10th Circuit, he sat on the panel and said, you know, I think maybe it's time for this Quill decision to be over. So we knew we had those votes, but we didn't know if we had any more. And what was clear after oral argument is that we had Justice Ginsburg's vote. And I have to tell you this story because I think it's quite incredible. I've seen probably 100 oral arguments in my lifetime. And I don't think I'd ever seen Justice Ginsburg as animated as she was over this issue. I mean, she just was asking questions right and left. She's just not that kind of person. She's not someone who's really assertive in oral argument. So it was very gratifying to see a liberal, a woman that, you know, many of us admire, you know, really interested in this issue. But the problem was we had no clear 5th vote, which created for a very tense 2 months. So the court, it's a big deal for the Supreme Court to get rid of precedent. It rarely does this. But the court, you know, for those of you who have lobbied on the Hill in Washington, you've gone to you went to your senators many, many times asking them, please get rid of this rule. The court said all the things that you were saying to your legislators for years. But like I said, it's a big deal for the court to get rid of precedent. But again, the court looked at all those facts, you know, the fact that the marketplace has changed and that, you know, we have all sorts of online sales and taxes aren't being collected. The court rejected the idea that it should wait for Congress, as Justice Ginsburg pointed out. We created this rule. Why should we wait for Congress to fix it? So here's how the votes ultimately came down. It was Justice Alito who provided that crucial 5th vote that we needed. And there's some irony in this case, perhaps, that so you and I know, right, that this case is not about raising taxes, right? But really, people think it's about raising taxes. So there's some irony in the fact that there were the 5 conservatives and a liberal, 4 conservatives and a liberal voted to raise taxes. So that was kind of something funny that people took from the case. The other thing is that why Justice Alito provided that 5th vote. So the union dues case does not impact Arizona, but it is a huge case nationally. I'm sure some of you read about it on the news. It again involved overturning precedent. Justice Alito had been the champion of that issue. He'd been working on that issue on the Supreme Court for the better part of 7 or 8 years. Everyone knew that he was going to write the opinion overturning this union dues precedent. I think he was worried about looking like a hypocrite. In one case, refusing to overturn precedent, and another case, agreeing to overturn precedent where he was writing the decision. So I think that's why he provided the 5th vote. I also think we lost some of the liberal votes for the same reason. They weren't going to vote to overturn precedent in the union dues case, and they didn't want to vote to overturn precedent in this case, but they knew there was enough votes to do the right thing, if you will. So that's kind of why I think the case turned out the way it did. So like I said, the court basically said, we're going to get rid of that physical presence rule. So to make an out-of-state retailer collect, they have to have some sort of substantial nexus with the state, meaning they have to be doing a certain amount of business with the state. And the court said, you know, $100,000 worth of goods, 200 transactions, that sort of sounds like a lot of business, or enough business to us. The court also said, it's important that South Dakota has promised us that it will not collect taxes retroactively. And that just kind of makes sense. And then South Dakota is part of the Streamlined Sales and Use Tax Agreement, and the court emphasized that twice in its opinion. So I'm going to talk about that in a second. So the dissenting opinion was written by Chief Justice Roberts. He made all the predictable arguments, except one interesting thing about the case is that he said, look, I agree that Quill was decided wrongly. I don't even have a problem, and all the justices agree, but I think, we should keep precedent because we've built an economy around this precedent. Why should we make these changes? And Congress can solve this problem more easily than we can. Agreed. But, Congress wouldn't do it. The dissent was also concerned about what about these small businesses? How are they going to be able to collect? Isn't it going to be difficult for them to do so? And Justice Kennedy's majority opinion was basically like, look, someone will come up with some software. We'll figure this out. It's not going to be me, but someone's going to figure this out. And that was kind of his take on it. So you all in Arizona, you might be wondering how much money you might get. So there's the GAO, the Government Accountability Office, did a report a couple months before oral argument, and it gave a high and low estimate of how much money you'll collect a year, in theory. So for Arizona, $190 to $293 million annually. So only time will tell whether you collect that amount or some different amount, but at least you have some sort of an idea. So now I'm going to talk a little bit about, go ahead.
I'm sorry, do they break it down by cities?
No, wouldn't that be nice, right? No. No, it's a good question. It's worth asking. So now the questions are, what are the collection issues for all of you as Arizona cities going forward? And so I'm going to talk about some of those issues. And basically, the most important point for all of you at this point is this. I guess you have a revenue ruling, like a tax ruling on having sort of an expanded economic nexus in Arizona, but you haven't had your state legislature come up with a law like South Dakota's yet. And probably, I think I even Googled this before I came, your legislature maybe ended its session in May. So what's happened if you have unless your legislator, and some legislatures did this, they acted before the Supreme Court ruled. They came up with a law, they put it on the books, and they said, I don't know why I keep on hitting this microphone. I guess I'm using my hands too much. They said, if the Supreme Court overturns the Quill, now we'll have this law ready to go. Arizona did not do that. And you're probably not going to have a special session, because you probably already would have. And so you have to wait really to January for your legislature to act. So what does that acting look like? Well, one of the things is your legislature might join the Streamlined Sales and Use Tax Agreement. Now, Arizona is not currently in this agreement, and there is some reason for you as local governments to want to be in this agreement, and I'll tell you what it is. I'm not an expert in the Sales and Use Tax Agreement, but this is my understanding of it. So what it does is it basically simplifies tax collection throughout your state. And the advantage for local government is that and this is probably really inaccurate, but it's the most simple way of describing it. Imagine this scenario, okay? Amazon has to give a check to state and local government. So what it does is it sends one check to the state, right? But then does the state turn over the money to you guys? That's the question, right? Maybe it does, maybe it doesn't. In this part of the Streamlined Sales Tax Agreement is that something like 2 checks are cut. One check is cut to you and one goes to the state. I don't mean that in a literal way. What I mean that is that there are provisions in the Sales and Use Tax Agreement that make it easier for local governments to collect their taxes. Because what happens right now, as I understand it, in a number of states, is that you guys have taxes, local option taxes, and they don't actually come to you. This may not be a problem in Arizona, but it's been a problem in other places. So the Supreme Court said, like I said, twice in its opinion, join the Sales and Use Tax Agreement. So now, as you're going to your legislator in January, if you ever wanted them or ever have had some motivation to get them to join the agreement, it's now, because it gives cover to what they do in terms of the general law they're going to pass. So there is some incentive for your legislature to agree to join this agreement, because it provides some cover in ensuring that the law that they pass to collect taxes is not unconstitutional. So just keep that in mind as you go through lobbying. So there, like I said, you guys are not a part of the agreement. So then another thing that your state legislature has to do is you have to come up with an economic nexus, or you probably will come up with an economic nexus test, like what South Dakota did, so that not everyone in your state has to collect. Not every mom and pop has to collect. Only businesses doing a certain amount of business. So your state hasn't done that yet through legislation. Most states haven't yet, but it's going to be on the horizon. So here you can see it's hard to see which states have acted and which haven't. So another big issue as I understand it, is with the Amazons of the world. So Amazon collects for itself, and they collected for a long time, but what they don't do is collect for their marketplace. So sometimes you're buying an Amazon product, right? Sometimes you're buying through a marketplace seller who's just selling on Amazon and isn't part of Amazon, if you will. It's hard to sort of explain. Some states have passed laws saying to the Amazons of the world, you will also do the tax collection for the marketplace sellers, for essentially the small sellers on your website. So not a lot of states, as you can see in the blue here, not a lot of states have acted on this yet. The blue is the states that haven't acted, but you're going to see some action on that because a lot of money is being left on the table when the Amazons are doing this marketplace collection or eBay or whatever, making these platforms sort of collect. Another issue is, when is your enforcement date going to happen? Again, a couple of states have picked enforcement dates. You have it in Arizona, again, because of your legislature not getting on top of it yet. So most states are picking the $100,000 transaction or 200 transaction standard. Some of the bigger states have picked a bigger threshold. Ohio's picked $500,000. I can't remember. Some other states have as well. Hawaii, for some reason, is trying to collect the tax retroactively. I've invited myself to Hawaii to explain why not to do that. No invitation has been forthcoming. I do not recommend any legislatures in there or legislative staff do not collect retroactively. It's a terrible idea. So like I said, I think the challenges for you guys, as they've been explained to me, I'm not an expert in this, is that sometimes you can have some problems getting the state to turn over the money to you. The Institute on Taxation and Economic Policy also did a report in March of other problems that local governments have collecting. It's sort of beyond the scope of my presentation to describe all those problems. But the long and the short of it is that your work on this issue is not done. The Supreme Court victory is, of course, huge, and it means that you can get this money, but more has to be done on it, and a lot of that has to come through your state legislature. So another really big case that the Supreme Court decided this term was Trump versus Hawaii. This is a travel ban case. And what the travel ban did, or what the version of the travel ban did that was litigated in this case, was it indefinitely banned people from immigrating to this country from the countries on this slide. And there's an asterisk next to Chad because ultimately Chad was dropped from the travel ban. And when this third travel ban came out, there was a lot of hoo-ha about Chad being included because most Americans don't know much about Chad. It's an African country, it's a poor country, but it's aligned with the United States. We do military exercises with them, and they're a partner in the war on terror. And the word on the street, and I never found anything to contradict this, was that Chad lacked passport paper. And I always sort of said, well, what if the people that hated the travel ban could have come up with a GoFundMe campaign and gotten money to Chad for passport paper? But it sort of illustrates some of the politics and some of the drama of the travel ban, which I'll talk about more in a second. But ultimately, it was only really five countries, and the travel ban was upheld 5-4 as lawful and constitutional. And this was not a big issue for most cities, but a lot of the major cities in the United States were actively involved in this litigation, led by Chicago. My predecessor had actually works for the city of Chicago right now and runs their appeals, and she had been sort of in charge of the nationwide city litigation over this issue. But I learned the hard way that this issue had impacts in places that I didn't expect it to, particularly in resort areas. I talked about this case in Utah, in a small session of people, and they were very concerned about it in Park City, where they have a lot of tourists and a big travel industry. It's also a very important case culturally and politically, I think, and there's a hidden legal issue that's very important in cities, and that's why I'm going to talk about this case. So there are two really important facts about this case. One of them that you are very familiar with, and one of them you might be less familiar with. And the one you might be less familiar with was there's actually 3 travel bans, and this was litigation over the third travel ban. And the third travel ban was very different than the first 2 travel bans. The first 2 travel bans, basically President Trump was like, okay, today I'm banning these countries. And that was kind of the end of it. And the third travel ban was very different. What happened was the United States government, through the Attorney General, through Jeff Sessions, did a nationwide look at the security procedures of all countries and to determine what they do to allow people to come into our country. About 30 countries were found wanting. So the Department of Justice went to those 3 countries and said, get your act together or we're banning you. And about 7, 8, 9 countries said, we're not getting our act together or we can't get our act together. And those are the countries that ended up on the trial ban. So it wasn't just like, President Trump one day announcing a bunch of countries and people sort of spinning their wheels. It was done more deliberately. The second fact about the trial ban I think is more well known is that President Trump made many anti-Muslim statements throughout the course of his campaign and throughout the course of his presidency, and probably most significantly, in my opinion, long after the 3rd trial ban became the law of the land. Remember those videos? They were from England, and they almost looked like jokes. I mean, they were so over the top, like a guy in a big beard smashing a statue of Jesus. There was 3 of them, and they were from like a hate group, and anyway, President Trump's second in command in communications said after those videos came out, well, I mean, this is why we have the travel ban. And so that was that was the factual context of where the case arose. So there basically are then 2 legal issues. One was, does it violate the Immigration and Nationality Act to say people from particular countries cannot come into our country? And then does it violate the Establishment Clause to basically have a travel ban that was, it looks like was based on religion. So those were the 2 questions. So the Immigration and Nationality Act has really broad language for the president, saying that the president can suspend the entry of all aliens or any class of aliens if he finds that their entry would be detrimental to the interest in the United States. This is Justice Roberts' sort of language. He likes to use very colorful language. He describes this language as exuding deference to the president. Essentially, if the president wants to say a class of people can't come to the United States, the law seems to pretty well allow it through very broad language. But some of you might remember also the talk about the fact that the INA also says that that we can't discriminate against people entering in terms of national origin. But the court said if you look at that language, it actually applies to the issuance of visas. So there's sort of 2 considerations. One, what class of people can be admitted to the United States? And in making that determination, you can eliminate countries. Then when you determine what that class is, then you can't discriminate against people in that class based on national origin. So it's kind of like there's a 2-step process. The court said it's okay to eliminate people in the first cutoff based on national origin, but not in the second cutoff. Does it make a lot of sense? I don't really know. But the court also pointed out that Reagan and Carter had also banned people from particular countries from coming into the United States. So the Establishment Clause is very interesting. It's got a lot of media attention, which I'll talk about in the second. What the court basically said was, look, considering the president's language was neutral, or the language in the travel ban was neutral, and considering that this has to do with national security, and considering this has to do with people entering our country from abroad, we're just going to give what's called a rational review or a quick glance at the travel ban. We're not going to dig too deeply into it. We're not going to look so much into the president's motives. And when we look at the travel ban and we just read it, it seems like there's a rational reason to have it for national security purposes, and we're going to leave it at that. Now, the mainstream media's coverage of this, I thought, was really pretty inaccurate. They portrayed the Supreme Court's opinion as basically saying that the president's statements were irrelevant, they didn't make any difference at all. What the court said more technically was, we're not going to look closely at these statements because this comes up in a national security context and the immigration context. Now, it doesn't, in the run-of-the-mill cases, we look more carefully. This may not give a lot of comfort to other people who are annoyed with other things that the president's doing related to immigration. But I do think there's something to be said for the court saying, look, we're just not getting a close look in this narrow circumstance. This case was portrayed as a win for Jeff Sessions, and I couldn't agree more. I don't know what would have happened had the first and the second trial ban been before the United States Supreme Court, where the president, like I said, just kind of pulled out these countries and said, hey, I'm banning these countries. But for better or for worse, the Department of Justice did a nationwide review of all the countries, like I said, asked them about their procedures, and then concluded, hey, these are countries that aren't doing what we would like them to do. I think another interesting point about this case is that what Justice Kennedy is really sort of famous for is knowing how far to push things in our country. And where the American people are really willing to go. The best example of this is the same-sex marriage case. I remember when that came down, I thought to myself, so, are the American people going to accept this? I mean, our marriage license going to be issued? Is this going to happen? And people may still disagree with same-sex marriage, but it's widely accepted, and there was no revolt as a result of it. And so I felt like, Kennedy pushed things, his pushing was okay. With the travel ban, I felt like the reaction to this case wasn't maybe as negative as I expected to be, maybe because Americans had gotten used to the travel ban, and maybe because it was kind of limited. And I think most Americans don't have a family member who is directly affected by the travel ban. And I think something like same-sex marriage, the Affordable Care Act case, we all had somebody that we knew who was affected by that. So people had more reason to have strong feelings about it. But like I said, I think it's an interesting case for our culture. And like I said, there is a hidden legal issue in this case that didn't get a lot of attention. For those of you who follow the news and love court issues, what you've been hearing about is courts issuing nationwide injunctions right and left. Nationwide injunction over WOTUS, nationwide injunction over sanctuary cities. The courts can't issue enough nationwide injunctions. So what courts typically do is they issue injunctions. This is like a legal order saying someone can't do something between two parties, the parties that are suing each other, not between one party and the rest of the world. Or between, and I guess in the travel ban case, what the parties who were suing over the travel ban wanted was that not just the people, that anyone who could possibly be affected by the travel ban, that the travel ban wouldn't apply to them. So if you were one of the people that sued, you would win your case, essentially, and then also the people that were in your class but hadn't sued would also win, essentially. That's sort of how a nationwide injunction would work. And the Supreme Court has not done much ruling on nationwide injunctions. But what's interesting is that Trump won in this case, right? So there's no nationwide injunction issued against him anymore. So the Supreme Court had no chance to sort of say what the standards were for nationwide injunctions. But since then, there's been more litigation in the sanctuary cities area. And this is, again, where the sanctuary city executive order courts had said, Trump administration, your sanctuary cities executive order doesn't apply anywhere. We're striking it down throughout the entire United States, throughout the entire world, whatever. Since then, a couple of courts have said, nope, we're just going to issue an injunction between the parties. So the parties that sued, the travel ban doesn't apply to them, but the travel ban can apply in other places. So that is kind of an interesting impact of the case. Even though the court didn't rule on it, the fact that Justice Thomas, in a dissent, was very critical of nationwide injunctions, I think has affected the court. And going forward, we're going to see more litigation on these nationwide injunction issues. So the Masterpiece Cake Shop is an interesting case. This is the case that, sadly, in my opinion, probably got more attention than any other case this term, and maybe than all the other cases combined. And why it annoys me that it got all this attention is that it's really kind of, in some ways, a very narrow case, but it's one that sparks a lot of curiosity and sparks very strong opinions for people, and I think that's why people had such strong feelings on it. And it has particular relevance in Arizona. So this case, for those of you who are unfamiliar with it, it involved two gay men who were going to get married. They went to a cake shop in Colorado, and they said, we want a wedding cake. And the cake shop owner said, I'm a devout Christian. I do not think your marriage is moral, and I don't want to make a cake for you. And I think it violates my religious beliefs to have to do so. So the couple sued the cake shop owner, and what they basically said is Colorado has, and all of your states have them, a public accommodations law. You have to basically serve everyone. But their public accommodations law also includes sexual orientation. So you can't just reject someone on the basis of race if you provide services in the open market. Race, gender, all those other things that we typically think of as protected. In Colorado, sexual orientation is protected as well. How this case ultimately played out was very, very interesting. The court basically decided nothing in the case. What the court said was that the Colorado Civil Rights Commission that first heard this case had expressed a good deal of anti-religious bias towards the cake shop owner. And I'll just show you what this guy particularly said. He basically was saying, religion has been excused to justify slavery, to justify the Holocaust. Like, why should we listen to your religious objectives? And I should also back up, I guess, and say that the cake shop owner said basically that he had a free speech right not to make the cake, to not be forced to engage in speech that he didn't want to engage in, and a free exercise of religion right to not make the cake, that making the cake would have forced him to act against his religion. So those were his arguments. And on the other side, the gay couple said, no, we have a right to not be discriminated on the basis of our sexual orientation. So that was the tension in the case. And so a number of you, now Phoenix has a public accommodation, or I'm sorry, Arizona has a public accommodation statute. It does not cover sexual orientation, but a number of your cities do, particularly the big cities. And there may be more cities that have one of these ordinances as well. These are just the ones that I know about. So, like I said, what happened in this case is that the court ultimately didn't say whether the public accommodation statute protected this couple, or whether the cake shop owner had a First Amendment right not to make the cake, or a free exercise right not to make the cake. What the court said was, this Civil Rights Commission did not take this man's religious objections seriously. They did not hear him. They made fun of him, essentially, and they treated him poorly. In my opinion, as a technical matter, the court really wimped out, and here's why. So I know this is getting a little bit into the technicalities. So when the Supreme Court reviews a case, they review it in what's called de novo review. That means of the new. That means that everything that happened before doesn't matter. They look at the statute, and they can decide for themselves. Does this statute violate the First Amendment? Does it violate the Free Exercise Clause? They don't have to care what the Civil Rights, what the Commission did in Colorado. That's all ancient history. So, and this is what the dissent points out. They're like, give us a break. You can just ignore the Colorado Civil Rights, Commission and decide this issue. But the court didn't do that. And this is why. Justice Kennedy, I think, really did not know what to do with this case. This is a case that I think really bothered him. So Justice Kennedy loves religious freedom. He loves the idea that people should be able to celebrate religious freedom. But he loves states' rights as well. He thinks states should be able to do what they want. He loves gay rights. So all those things that he loves free speech. So all these things came together in this case in a really unpleasant way, in a way that made it really hard for him to decide what to do. And so I have to go through this with you because it's really sort of funny. So this is the oral argument transcript. And Justice Kennedy is talking to the lawyer who is defending the Carr Civil Rights Commission. And he says, basically, did the Carr Civil Rights Commission ever, disavow the fact that their colleagues said this? And the lawyer said, no one discussed it any further. And then Justice Kennedy goes on to say to the lawyer, well, do you disavow these anti-religious statements? And the lawyer is like, well, I would never have advised my client to have said that. And then Justice Kennedy is like, right now, in this oral argument, do you disagree with what that guy said about religion? And the lawyer's like, yes, I disagree with it. But that just illustrates, like I said, how mad Justice Kennedy was about this commission expressing all this anti-religious animus towards this individual who had a sincerely held religious belief that he shouldn't make the cake. So the big question out of this case was, what does this case mean? What are the takeaways, given that the court really sort of didn't decide anything? A lot of people have cited this language on the screen, where the court basically says, and it's important to note this, 9 justices agree to with this language. The court basically says, look, in our society, we generally say, if you have a business, it has to be open to everyone. And we're not really, at this point in our history, we don't close our doors to gay and lesbians, and that's just not where we're sort of at culturally. And a lot of people think that this will be the big takeaway from the case, but only time will tell what the big takeaway will be. But how this is relevant in Arizona is, of course, a couple of days after this case came down, you had a ruling from, it was either the Arizona Supreme Court or the Arizona Court of Appeals, and it was involving the Brush and Nib studio. This is like, it's not like wedding products, sort of. They also did not want to sell products to a gay couple. And the courts basically said, no, like you have to make the sale. By making a sale, you're not, no one was disparaging your religious beliefs just because you have to make a sale. And this case isn't really about speech or art. It's about refusing to sell to someone, and you just have to, you can't do that. And I think the bottom line for the court was this: you can keep your beliefs, your religious beliefs, whatever they might be. You can have them, and we're not saying you can't have them, but you just have to sell to everyone. And I walked to the door, and the court also said, if you wouldn't sell a product to a same-sex couple. Like, you wouldn't sell a same-sex couple a Nazi symbol cake. You don't have to sell a Nazi symbol cake to a gay couple. But the court said that's where we're just going to sort of draw the line. So it's interesting. Obviously, the Arizona court was waiting for the Supreme Court to decide this case, and there was plenty of language for the court to have gone the other way. But it didn't. And it'll be curious to see how this issue plays out. And it's going to be before the Supreme Court probably again. There's another case called Arlene's Flowers that the court sent back involving a flower shop. And there, the wedding vendor also said she was treated discriminatorily on the basis of her religion, or her religion was disparaged. But what's different in, I guess, the Brush and Nib studio case was that no one claimed that the vendors in that case were disparaged on the basis of their religion. But like I said, the law in Arizona is, the law in Arizona, as you know it, is that for those states that, or those cities that have the ordinances that protect on the basis of sexual orientation, if you are a wedding vendor, you have to provide services to gay and lesbian couples as well. Okay, so this is my trivia question for the political nerds in the room. There are 2 answers to this question. What do these states have in common? 2 answers. What? Did someone say great food?
College football.
College football. You are the lamest audience ever. No, this is for political junkies. Okay, this is not a hard question. Okay, swing states. That's one answer. There's another answer. Think about the Supreme Court. They are the most partisan gerrymandered states in the country. No coincidence that they are the swing states. This is another topic where I've learned the hard way that I shouldn't assume. You're a very red state. Arizona is a very red state. But I don't assume that you don't care at all about partisan gerrymandering, because first of all, you have some people that are not in the red majority. And second, again, when I was in Utah, they were very concerned about partisan gerrymandering in Utah, even though they're also a red state as well. I'm not going to spend a ton of time on this case because nothing much happened in it again. But I couldn't ignore partisan gerrymandering because it's such a big deal. So for those of you who, although I don't know, it sounds more like you guys would be interested in sports podcasts, but for those of you who like podcasts, there's a podcast called, I think it's, I can't remember if the podcast is called Into the Thicket or the episode was called Into the Thicket. Anyway, it's, or the Political Thicket. It's a podcast about Baker versus Carr. So Baker versus Carr was the decision that led to the Supreme Court saying, one person, one vote in the United States. And so the backstory is, why I bring up this podcast is that Chief Justice Earl Warren was interviewed at the end of his tenure. And remember, this is Earl Warren, okay? Brown versus Board of Education, Miranda. Basically, all of the court left-wing agenda for the last century was accomplished in the Warren court. If it's liberal and it's big, Justice Warren was responsible for it. He was asked, what is the most important Supreme Court case you ever sat, or decision you're involved in? And he said, Baker versus Carr. And it was, this little known sort of one person, one vote case. But the truth is that one person, one vote made a huge difference because, in Tennessee at the time, it hadn't been redistricted since like the 1900s. So it could be that your vote was 50 times more valuable in a rural area than in a city. It was really quite incredible. But the reason why you need to listen to the podcast is that the result of the case, there was a justice, I can't remember his name, he had no ideology. He was just like a regular nice guy from the Midwest. He had no ideology. He did not know what to do with that case, and he ended up losing his mind and leaving the court. But then the decision ended up not even being 5-4. But anyway, I think, like I said, it's called the Political Thicket or the Political Question. It's absolutely incredible, and it illustrates the importance of partisan gerrymandering. So the long and the short of partisan gerrymandering is sort of this. The Supreme Court said in the 80s, some amount of partisan gerrymandering violates the Constitution. We don't know what that number is, but we hope we can figure it out soon. Well then, here we are 30 years later, and they still haven't figured it out. In the 90s, or in the 2000s more significantly, Justice Kennedy had said in 2004, you've brought me a number of tests to determine when partisan gerrymandering is just too much, but you haven't brought me the right one yet. Keep on looking. Keep on working with your mathematicians. Come back to me. Let's talk. So it took about a decade, and a new theory of partisan gerrymandering came up. And you might wonder, why does this matter to local governments? The reason why it matters to local governments is that research indicates that in these 5 states, There is more preemption legislation than there are in other states. The idea being that, and that these legislatures don't necessarily represent the voters all that well due to partisan gerrymandering, and that the consequence of that has been, because the legislatures have been so controlled by Republicans, that the result has been more of these state legislatures, either for that reason or other reasons, sort of taking over local government. So that's why local governments need to care. The court had 2 chances this term to come up with a standard for partisan gerrymandering. It failed to do so in both of the cases, and they're very complicated and very difficult to explain, but the short version, I guess, that the Wisconsin case is the most important case. So basically and they came up with a new theory, a new idea in this case. So Wisconsin, about 50% of voters are Democrats. About 65% of legislatures are Republicans. Doesn't quite seem right. And they came up with a mathematical model for testing wasted votes. It's called the efficiency gap. And they said, we think an efficiency gap of over 7% is just too much. Wisconsin was about 11, 9, depending on what year it was. And that was their theory. But what the Chief Justice wrote in his opinion was basically, the problem with looking at partisan gerrymandering from that perspective is that just shows what the harm is for the statewide basis. You're not electing enough Democrats for the state. You have to show that you're individually harmed for us to rule in your favor, and that didn't happen in this case. So the court, in some sense, didn't buy the efficiency gap argument. What was very interesting in the case was that Justice Sotomayor and Justice Kagan, led by Justice Kagan, 4 liberal justices, kind of wrote an opinion saying, imagine if this case had been argued a little bit differently. Imagine if it had been argued in this way, and they explained how they think it should have been argued. Boy, we think that there might have been a finding of partisan gerrymandering. So that's kind of the roadmap for the parties going forward. Why did Justice Kennedy not join that opinion? Had he joined that opinion, there would have been 5 votes to say this is too much partisan gerrymandering. It's a really good question. And I think the answer is the opinion was quite speculative, because it basically, like I said, it said, if you'd have argued these things, you might have gotten farther. Well, they didn't. So, that doesn't seem quite fair that the court can kind of make their argument for them. I think the other thing is Justice Kennedy knew he was retiring, and he knows he's not the future on the partisan gerrymandering issue. And I think he didn't think this case or the test was good enough, and that's sort of what held him back. Now, for court watchers, what was interesting in this case was that the speculation after this opinion came down was that Justice Kennedy was for sure staying on the court. Why? Because that concurring opinion written by Justice Kagan was described as a love letter to Justice Kennedy, kind of like, Justice Kennedy, if they do all these things right, will you come and join us? And so people were like, okay, this means he's staying. It's just that they have to do all these things right, and then Justice Kennedy will rule in their favor. So that didn't happen, and so now the dialogue, I guess, is partisan gerrymandering, is it over? Oh, and that's it. More perfect, the political thicket. That's what you have to, that's a podcast that really talks about the history, not so much of partisan gerrymandering, about one person, one vote, and how important voting is in our country. So now the question is, the question initially after the case came down was, does this case make it harder or easier to bring partisan gerrymandering cases? Some people said harder because now you've got to meet this high threshold that the Chief Justice laid out. Some people said easier because now at least there's a threshold to meet that we all can agree on and we can understand. Well, as soon as Justice Kennedy left the court, the conversation changed. Are we going to do, is the court going to do anything about partisan gerrymandering at all? The quick answer is, as long as the court has 5 solid conservatives, no, nothing will be done about partisan gerrymandering. But I should say this, it is not just Republicans who partisan gerrymander. It is Democrats as well. The Maryland case involved a testimony from the governor of Maryland saying, I partisan gerrymandered these Republicans out of the state and I'm proud of it. So it's not just Republicans, but the Republicans tend to be more, or Republican appointees, conservatives, whatever, tend to be more skeptical of the idea of taking authority away from the state legislature. Because that's what you do when you come up with a standard for partisan gerrymandering, is you're saying, okay, state legislature, it's no longer do what you want, it's do what you want to this point. And so as 5 solid conservatives, I don't know that the court's going to do anything on partisan gerrymandering, but there's 3 things I think that are worth thinking about. One, lower court over lower court after lower court after lower court have said to the Supreme Court, okay, so you won't come up with a standard for partisan gerrymandering? Watch us. And they may continue to do that and continue to push the court to do something. I also had this is my personal theory. was that the partisan gerrymandering in Wisconsin wasn't actually all that bad. It was bad, but it wasn't all that bad. And because of the collection of data and math modeling, the litigants in cases are able to say things like, this is the 5th worst partisan gerrymander since 1965. And I'm really not kidding about that. Michigan, so no matter what you make of the efficiency gap, whether you think it's stupid or you think it's the greatest idea ever, Michigan, there are jurisdictions in Michigan that have an efficiency gap at the 20% margin. So I think the court in some ways hasn't seen anything yet, but North Carolina and Michigan are more than happy to provide it. And then what you have, interestingly, is states like Pennsylvania, which have come up with a state constitutional remedy for partisan gerrymandering. So we may see some of that going forward. So now down from the big cases and onto a little bit more of the mundane. Lozman versus City of Riviera Beach is one of these cases that is, well, how would I describe this? It's like a warning for all local governments. It's really kind of a crazy case, but I think it actually happens more often than you think. So the issue that the Supreme Court was supposed to decide in this case was whether the existence of probable cause defeats a First Amendment retaliatory arrest claim as a matter of law. Now that sounds like a bunch of legal mumbo jumbo. And the court ultimately really didn't decide that case. So to understand what they really did decide, I have to tell you about the facts of this case. So Fane Lozman is like the ultimate rich gadfly. He moved to the city of Riviera Beach in 2006 in his floating houseboat. And he moved into this city-owned marina. So he found out that the city was going to make some changes to the marina using eminent domain. He became an outspoken critic of the city. In fact, I think in a year's time, he made 200 comments at board meetings, or maybe it was over a couple of years. Anyway, he became an outspoken critic of the city. He sued them over multiple things, including a previous Supreme Court case involving whether or not his houseboat was a vessel for maritime law. It's actually a floating shack. And he sued the city. He sued the city for open meetings violations. Now, this is where the plot thickens. There was a city council meeting where, in a closed session, a council member said that she basically wanted to intimidate Lozman, and and the city basically said, all we agreed at that meeting was that we were gonna fight the open meetings litigation. But Lozman said, no. What the city did in that meeting is they came up with a plan to come after me, essentially. So what happened was, 5 months passed after this meeting, and he was yet again talking at the public comment period, complaining about corruption of county officials. Now, meanwhile, this is a city council meeting. So the president or the chair of the city council said, basically, Lozman, you got to shut up, because in the public comment period, you can only talk about city business. Corruption of county officials, that doesn't affect us. You need to stop now. He wouldn't stop, and he was arrested. And here's the thing. You can watch the whole video on YouTube. It's about 29 seconds to watch him get arrested. I mean, it happened really, really fast. So he's charged with resisting arrest and disorderly conduct, but the charges were ultimately dropped. So he sued the city for violating his free speech rights. He said, basically, city, you're saying that you arrested me because I wouldn't sit down and shut up when you told me to. But really, you arrested me because you're mad that I sued you, and you're mad that I bother you all the time. So the question was, but he ultimately admitted, I was arrested for a legitimate reason. You could have arrested me because I refused to stop talking. I agree, but the real reason you arrested me is because of my First Amendment protected speech, so I should be able to sue you. So even though there was probable cause to arrest me for another reason, I should be able to sue you because you really arrested me because of my free speech. That was his argument. And so the Supreme Court basically said, in general, we're not going to decide whether someone who has a First Amendment retaliatory arrest claim, but there's also probable cause to arrest them, can proceed with their First Amendment litigation. We're not going to decide that question. We're just going to say that Fane Lozman, in this particular case, can proceed with his First Amendment case. Why? Because Fane Lozman, it appears, was a victim of a retaliatory plot by the city. So most of these First Amendment retaliatory arrest cases happen between police officers, where a police officer has to act quickly, someone's wearing a Make America Great hat, and then won't cooperate with the police officer, says, I was arrested because of the hat, not because of my non-cooperation. So those are the typical cases. The Supreme Court said that's not this case at all. This case is some guy who argues that the city was in a plot to discriminate against him. And so the court said in this situation alone, he can bring a case. The court also said, Mr. Lozman may not win at trial because it may be the case that the city would have arrested him anyway for his completely obnoxious behavior, regardless of anything he had done in the past. It was very interesting that the court was really sort of torn about what to do in this case. It described the video of the city council having Lozman arrested as chilling. But it said, on the other hand, we're very concerned about these police situations where police officers have to act quickly. And interestingly, right after this case was decided, the Supreme Court accepted another case of the Ninth Circuit, which is the federal circuit that you're involved in. And this case involved a guy who was drunk at Arctic Man in Alaska and was being uncooperative with police officers who said, basically, I was arrested because I refused to speak with a police officer, not because I tried to shove his colleague. So that is the case that will go before the Supreme Court. But it's kind of an interesting, I would say, it was an interesting, it's an interesting case for city council people in this sort of sense. When I've gone through the United States and I've talked about this case, I had a lawyer come up to me and say, we threatened to arrest someone at every single board meeting. I was like, wow, that's kind of crazy. But the point is, you all have gadflies. You all have people that cause trouble for you, who cannot stop and are relentless. And they are the people that are likely to sue you if you make one sort of little mistake. And I think the sort of lesson learned, the lesson that I would take from this case is that people had come up to me before the case was decided and said, we don't even have to provide a public comment period. We're worried that if we do now, we're going to have to tolerate all these gadflies, all this sort of crazy speech. And I think there is sort of a lesson. The court didn't get into any of that stuff. And in fact, the court said, look, we're not going to say whether the statute was overly broad. We're not going to say whether the policy was incorrect. But what we are going to say is that, there can't be a plot to sort of retaliate against someone. I do think, though, that this case does provide somewhat of a warning for the public comment periods that, while there's nothing wrong with limiting the amount of time that people can talk, limiting the viewpoint that they say, limiting the content of what they say, excluding a person entirely from public comment, excluding, being involved in a plot to exclude someone. All that is going to be constitutionally problematic, and I'm not surprised that the court, made a big deal about that. So yeah, go ahead.
My question, if you can answer it, is how did they know what was discussed in what I assume was an executive session?
Yeah, that's a really good question. I was actually thinking about that just as I was talking about it. I don't know. When the case was before the lower court, that retaliatory plot wasn't even discovered. I didn't even learn about it till I read the Supreme Court opinion. It's a great question, how that all came out. I'm guessing maybe there was some divisiveness on the board, perhaps some disagreement, something of that sort of thing. So the Carpenter case is one that I already mentioned. This is the case involving the cell site location data. As I said, we all have cell phones, and the cell phone ticks to the towers, and the cell phone companies keep records of all the ticking, and those records can be very helpful in finding criminals. And the Supreme Court had to decide whether or not to require a warrant for police officers who want to find this data. And what the court had done historically was said, if someone else has your records, like a cell phone company, or their healthcare records, or phone company records, and you don't have any access to those records, there doesn't need to be a warrant because you don't even know those records exist. The court said, this is a totally different business than that. With the cell site location data, you can basically track someone's movement every single day for every aspect of their life. This isn't some sort of like phone records that keep track of the 5 phone calls you made in a day. This is every movement you've made throughout the entire time of your history, and that basically people can't sort of avoid having cell phones. What I thought was really interesting about this case was I heard a professor talk about it, and she said, what happened in the Warren Court was that the Supreme Court came up with criminal procedures. And the criminal procedures applied to everyone, right? But they were specifically designed to protect racial minorities who are more likely to have encounters with police officers and more likely to have bad encounters with police officers. And the court said, look, this professor had said, look, we're kind of turning this on its head in this case because here what we have the Supreme Court saying is now every average American has a cell phone. And now every average American could have to have an interaction with the police. And that could be an unpleasant interaction. So let's make sure the police have a warrant. And when he says every average American, really, it's people that can afford cell phones and afford fancy cell phones. And so there is some sort of interesting politics of the court maybe sort of re-looking at their criminal procedure and wondering, and for us to wonder who is it actually intended to benefit. So this case, like I said, this is more a case that affects police officers, but there's nothing that Americans like more than cases that they can understand. And this is a very simple case. I mean, we all have cell phones, and Justice Kennedy was like, even I know my cell site location data goes to the cell phone company. This is a very human sort of case, and everyone loves the idea of people in their 80s trying to figure out technology and how it all works. And I think too that this case illustrates, some of the challenges of being a police officer. Having to follow all these rules, all these ever-changing rules, all these niche rules, and the court emphasized we're not deciding anything in this case but cell site location data. So if you're a police officer, I was just actually at a class reunion talking with one of my classmates who became a police officer about the Supreme Court's docket. I mean, he really and truly has to learn what they do every term and then has to put it into place in his job. So in the last couple of minutes that I have, I'm going to talk about the Supreme Court in general and about Justice Kavanaugh and what the future might hold for the court. So in this term, I think what was kind of interesting, because this has been true for every term, but maybe more true now than ever, was Justice Kennedy ruled the world. He was in the majority in all of the big cases, as I said. In South Dakota versus Wayfair, it was his case, his idea, his opinion. In the Kate case, he wrote the opinion, and it was his theory, as strange as it was, that triumphed in the case. In the partisan gerrymandering case, you saw Roberts and Kagan fighting for his mind and heart. He could have made that case go the other way, and he didn't. So I've wondered, why was Justice Kennedy so indecisive and so narrow this term? And you see this in the Kate case and the partisan gerrymandering case. I think it's because he knew he was leaving. He knew the future wasn't with him. And to decide these really cutting-edge questions, I think he wanted to leave it to a future generation. And other people have asked me, why was he so conservative this term? Because he is a conservative. He's been a conservative most of his career. But there have been times and impulses that he has that are not conservative. The other thing, too, that I really want to tell you, and this is the point that I really want to make in my presentation to all of you, is Justice Kennedy was on the Supreme Court for 30 years. And in this term, I saw him in four cases express anger at state and local and federal, state, and local government officials for showing animus, for showing bias, for showing discrimination, for showing a closed-mindedness. And just to review those cases, in the Kate case, remember, he was mad at the city, the Colorado Civil Rights Commission person who was anti-religion. There was another case out of the Ninth Circuit involving, this is an interesting case I'll just talk about for a second. It involved disclosures for pregnancy crisis clinics. Basically, pregnancy crisis clinics in California had to say, oh, by the way, we don't offer abortions, but if you want one paid for by the state, just go down the street. And what happened in the case was the California legislature had kind of congratulated and said, look, we're so open-minded. We're forcing these crisis pregnancy clinics that don't offer abortions to tell the whole world about abortions. And Justice Kennedy said, no, it's not progressive and open-minded for you to tell an entity that it has to say a message it doesn't believe in. Crisis pregnancy clinics don't believe in abortions. They shouldn't be forced to talk about them. That's not progressive. That's not open-minded. In the retaliatory arrest case, like I said, that was, again, his opinion, his idea, and he was very upset about Mr. Lozman being discriminated against or plotted against by the city of Riviera Beach. And then in the travel ban, okay, so this is the deal in the travel ban. He wrote a concurring opinion, and this is the last words he wrote on the Supreme Court after a 30-year term, and I'm going to read them to you. Because while you may see these words as being geared towards President Trump, they're geared towards all state, local, and federal government officials. So I will read them. There are numerous instances in which the statements and actions of government officials are not subject to judicial scrutiny or intervention. That does not mean those officials are free to disregard the Constitution and the rights it proclaims and protects. The oath that all officials take to adhere to the Constitution is not confined to the spheres in which the judiciary can correct or even comment upon what the officials say or do. Indeed, the very fact the official may have broad discretion free from judicial scrutiny, makes it all the more imperative for him or her to adhere to the Constitution and to the meaning and its promise. And this is the last paragraph. The First Amendment prohibits the establishment of religion and promises the free exercise of religion. From those safeguards and from the guarantee of free speech, it follows there is freedom of belief and expression. It is an urgent necessity that officials adhere to these constitutional guarantees and mandates in their actions, even in the sphere of foreign affairs. An anxious world must know that our government remains committed to the liberties the Constitution seeks to preserve and protect, and that freedom extends outward and lasts. Beautiful words, right? Beautiful words issued as a warning and as a statement, like I said, aimed at President Trump, but really I think for all state and local governments. It's really, like I said, I think it's, to me, is so remarkable that in this term, that was the theme after 30 years that Justice Kennedy picked out, is that he wants, expects, and needs all of you as elected officials to, uphold your oath and to act in an unbiased and non-discriminatory way. So what does this term say about our court, about the democracy and the role of Justice Kennedy? A lot, I can tell you. The Supreme Court is incredibly powerful. They decide, they pick and choose what they decide, when they decide, and how they decide. The Supreme Court never stops and rarely slows down. They decide many of the most important issues of the day, and they have the final say on constitutional matters. So the question for all of you is, should it be this way? Should our government be organized in this way where we have a judiciary that it has this kind of power? These are only 9 people. They are not elected. They are appointed for life. They are relatively homogeneous. They are not average, and they are never young. For better or for worse, these qualities make the Supreme Court nimble, decisive, and skewed. If it had to be this way, if it has to be this way, I think we were really lucky to have Justice Kennedy right where he was. Everyone in this room, regardless of what your politics are, everyone in this room has agreed with many of his decisions. In South Dakota versus Wayfair, I think we saw his humility and his curiosity. I would argue to you that he is the second most powerful, he's been the second most powerful man in our country for the last 12 years, other than whoever we had as president at that time. The last thing he has to do in that role is say, geez, in 1992 I decided that sales tax case wrong. I guess I should try to do something about it. But he did that, and you all will benefit as a result of it. And I think whether we like it or not, the Supreme Court, at least in my lifetime, has been, and certainly most recently, has been our collective voice and conscience. And Justice Kennedy made that a thoughtful, moderate, cautious, and open-minded conscience. And now he is gone. So where did he provide the critical 5th vote? Because that's the question that we have to ask ourselves, and when we wonder about what does it mean for him to leave. It was everything. Gun rights. He was the 5th vote in the Heller case. Death penalty. He and the liberals rolled back death penalty incredibly. We no longer execute minors. We no longer execute the intellectually disabled. All of that was done at Justice Kennedy's hand with the help of liberals. Affirmative action. The last vote he placed in an affirmative action plan was in favor of an affirmative action plan, something I thought he would never do. Abortion. The last vote he placed in an abortion case that actually directly involved abortion, he voted against an abortion statute. He had not done so since Casey. So he was no big pro-choice person, but he was a never say never. Same-sex marriage. Champion of gay rights. Land use. I mean, this is the one that affected me most personally in my job. If there's a land use case that goes before the Supreme Court, I usually get under my desk and cry. They all are decided against local government. We won one last term. Justice Kennedy provided the 5th vote. This is how it is. And then, Justice Kennedy provided the 5th vote in Citizens United, a case I'm always glad that I'm not really responsible for talking much about. So where was Justice Kennedy liberal? That's another big question as we face him being gone. The LGBTQ questions, for sure, that was one place where he was liberal. The death penalty, like I said, race sometimes, abortion sometimes, rarely, but sometimes. So who is Judge Kavanaugh? So it's a little bit hard for me to talk about him in a very definite way in some respects. But there are 3 things I can say about him for certain. He is very conservative. But he could be more conservative. And he's been rated as somewhere between Thomas and Gorsuch and Alito. So if you think of the right of the court, at the center were Roberts and Kennedy, who I would think is more moderate conservatives. So you can be in that crowd or you can be in the Alito, Thomas, and Gorsuch crowd. He will be probably in the Alito, Thomas, and Gorsuch crowd. He could be a more reliable conservative. For those of you who followed his record very, very closely, he did say that there's a compelling state interest to having birth control. A true hardcore conservative would say there is no compelling state interest to having birth control. He voted sort of indirectly to keep the healthcare case alive. Which is a long, sort of complicated story. So I don't think he's an ideologue. I think he's got some thoughts of his own. But in some ways, the most important thing to know about him, if you only had to know one thing about him, if I could only tell you one thing, he's conservative. And that, in a lot of ways, doesn't tell the whole story, but it tells a good deal of the story. Another reason why it's a little bit hard to talk about him is that he was on the D.C. Circuit. So the D.C. Circuit, the only local government in the D.C. Circuit is D.C. So there's just not a lot of local government cases that come out of the D.C. Circuit. What comes out of the D.C. Circuit is a ton of environmental law, a ton of administrative law. A full 1/3 of his opinions are about administrative law. If you think about Justice Gorsuch, I bet 10 of his opinions were on administrative law. So he's really skewed towards administrative law, which affects local governments but isn't that big of a deal. And the other thing too is, like I said, the D.C. Circuit just doesn't decide that many local government cases. It doesn't decide that many cases involving bread and butter, but it actually decided 2 cases. The court had 2 cases out of the D.C. Circuit last term, which is absolutely crazy. So what we've seen from him so far are predictable things that you'd expect to see from a conservative. Pro-employer, pro-qualified immunity. There was a great qualified immunity case last term that I didn't talk much about because it's not one of the more important cases of the term, where, I mean, this gets kind of technical. He had dissented from a denial of hearing en banc. All it basically means was he would have given the police officers qualified immunity where the majority of the court wouldn't. So that's a very good ruling for us. He's been pro-gun. He's pro-free speech. All the Supreme Court justices are pro-free speech. There are really no exceptions to that. It just depends on what version of pro-free speech you are. There's an interesting case about chalking, which is, writing with chalk on government property. He said that was not protected free speech. It's kind of interesting. He tends to be anti-agency deference. That can be good for local governments in most instances. He's anti-environmental regulation. That can be good as well. I think we can guess he'll be pro-property rights, anti-government in this case. He'll be pro-religion in public spaces. Again, not a lot of decisions in that space. He'll be pro-closing the courthouse door, which could be good for local governments. And I suspect he'll be anti-race-based decision-making. I thought it was very interesting. In his disclosure form, he listed a case where he concurred, where it was an employment case where someone had used the N-word, and he wrote a concurring opinion saying, one use of the N-word can create a hostile work environment that can be unconstitutional. That's significant in some ways because, in general, one statement, no matter what that statement would be, wouldn't be enough to be sexual harassment. But, the N-word is special in the United States, and we all recognize that. But I found it sort of interesting that he would cite that as one of his top 10 opinions, because he's definitely tried to portray, if you watch his speech with President Trump, talking all about women and talking about his love of women and then more on women, and then the wife and the 2 daughters, he's definitely tried to portray himself as a moderate. And my fear about him is that he's maybe the kind of conservative that thinks if we just got rid of the N-word, everything would be fine in America, and not really someone who really sort of gets the complexities of race relations. But anyway, that's some interesting. Those are some interesting tidbits on Judge Kavanaugh. So as you know, his confirmation hearing starts September 3rd or 4th, and there's, in Washington, there's really no dialogue about whether he'll get through. It's considered absolutely a done deal. It's already considered done, which is why I think I end up calling him Justice Gorsuch. The short version of the long story is he only needs 51 votes. Before Justice Gorsuch got on the court, he would have needed 60 votes. There's no way this guy could have gotten 60 votes. I can assure you of that. Because as we all know, Roe versus Wade, some people believe, I think it's very possible, is on the line here. So there's no way this guy could have gotten 60 votes. And so he has exactly that. I assume McCain won't vote, but Pence would vote in his place. I haven't been following this as closely. I mean, I need to get back on, following Susan Collins like she's my best friend. I did see an article where she said she talked to Kavanaugh and that he believes that Roe versus Wade is precedent, or settled law. Well, I believe it's settled law too, but I'm not a Supreme Court justice. And when you're a Supreme Court justice, anything can change. So to me, that is no assurance. The only assurance I would accept if I was Susan Collins would be, I will not vote to overturn Roe versus Wade. It is very different to say that than to say it's settled law. Everyone agrees it's settled law. There's no controversy over that. And just on that note, I will say one thing that I thought was sort of interesting. I watched the CNN coverage of Kavanaugh being nominated, and Jake Tapper said that he talked to Susan Collins and that he believed, or that Susan Collins believed, that Justice Gorsuch would not vote to overturn Roe versus Wade because he believes in precedent. And I wanted to say, Ms. Collins, are you aware that in the last week, Justice Gorsuch voted to overturn 2 huge precedent? Are you also aware that all Justice Gorsuch did when he was on the 10th Circuit was write opinions about the Supreme Court precedent he wanted to overturn when he got on the Supreme Court? So I'm a little skeptical, but what I've been saying about this topic, because I have people who will call me and say, Lisa, is Roe versus Wade going to get overturned? And I'm like, give me a break. I'm not a mind reader. I don't have a crystal ball. I don't know what's going to happen. What I would say about it, and more about Kavanaugh getting through, is that, like I said, the convention says he'll get through, but I think there's no issue like abortion to make people crazy. And if someone's willing to throw in the towel and just do something they wouldn't ordinarily do, it might be over the perception that Roe versus Wade will get overturned. But the conventionalism is he gets through and it's no sort of problem. And I don't have a great answer for what happens with Roe versus Wade. I do think if it happens, it will take time. It won't happen overnight. But for those of you who watch John Oliver or would be interested in this, he has this great clip of Jeffrey Toobin, who's like the legal guy for CNN, saying like, Roe will be overturned in 18 months, 9 months, 6 months. And all these clips of him saying it over and over again with different poses and different ties. I think it's hard to say sort of what the future will bring. I think there's maybe a chance the court would just avoid kind of ruling on the issue altogether. But, who knows? So I'll just talk very briefly about a few more cases on the court's docket. Because there is a case out of Arizona that impacts local governments, which is kind of funny. And are any of you familiar with the Mount Lemmon Fire District? Oh my gosh, we got a few hands up in the air, Mount Lemmon Fire District. So basically the Mount Lemmon Fire District had a couple employees, laid 2 employees off. They were the oldest employees, and they sued saying, we think we were discriminated against on the basis of our age. So the question is, does the Federal Age Discrimination and Employment Act apply to state and local government employers that have 20 or less employees? The language of the statute, I have it up here, is really sort of tricky. There's 2 ways of looking at the language. One way is to say that any employer that has less than 20 employees, ADA does not apply to it. The other way of looking at it is to say, for state and local governments of any size, the ADA applies to them. So that's the question before the United States Supreme Court. Again, kind of a very esoteric question, but important for these small districts. You probably have a lot of districts in this a lot of these small districts. I also, for the bigger cities, you may not even realize that you're dependent on some of these districts for providing you a variety of services. So that's kind of an interesting case. The Weimer House case, this involves this poor, unfortunate frog called the dusty groper frog. So the long and the short of this frog is that it used to live in Mississippi, Alabama, and Louisiana. And now it only lives in Mississippi. So the Fish and Wildlife Service said, we think it can live in Louisiana on this logging area right next to New Orleans. And the landowner, who happens to own all the timber or have timber rights for 50 years, said, maybe the frog could live here, maybe it couldn't, but we would have to radically alter the habitat for the frog to live here. And the Fish and Wildlife Services said, so what? We don't care whether the habitat has to be modified or not. The frog can live here. So the question is whether or not you can designate, or the federal government can designate land as a critical habitat if it has to be radically modified to actually provide the critical habitat. The other thing that happened in the case was that the Fish and Wildlife Services said, look, there's going to be all these benefits if the frog can live here. But they failed to consider the fact that this company was going to lose like $40 billion. But they just sort of ignored that. So the question the court has to decide is whether or not Fish and Wildlife Services and a court can just effectively ignore the amount of cost that modifying the land would take, or that not being able to get the lumber would take. It's an interesting case because it's easy to sort of feel sorry for the frog, because like the frog needs to live somewhere, right? But this also just seems like sort of one of those federal overreach cases, like really? You're going to force the frog to go somewhere where it can't even go right now? Like, does that even make any sense? Then you're going to ignore the cost and you're going to do all this and the frog can't even maybe live there even after you've done all the work. So it's kind of one of those like bad government cases. And the last case that the court's going to hear is Nick versus, that is of interest to you guys, is Nick versus Township of Scott. So the question in this case is whether or not, if someone brings a takings case, that case has to go to state or federal court. And you want it to go to state court because your states have come up with long processes and procedures for adjudicating these cases, because 30 years ago the Supreme Court said these cases have to be heard in state court. Also, you want state court judges who decide cases more quickly, who know about your laws, who understand property, who decide in this case. It's not a federal circuit, not a federal judge from Hawaii that doesn't even know where your state is on a map. And what's interesting about this case is that this case, if the court says these cases are not to be heard in state court but are to be heard in federal court, would involve overturning precedent. And the court has really been on a roll about doing that. And I'll just make one last point about that, and that is this. So for a long time, the property rights community has wanted the Supreme Court to decide this issue. But they've never agreed to hear it. Why? Because Justice Scalia rather, liked having these cases heard in state court. So now we have a new justice, Justice Gorsuch, who people suspect will be very pro-landowner, very anti-government. And so I suspect that Gorsuch was interested in this case and will rule with property owners and against state and local government, and that we're going to have only more of that to come when Judge Kavanaugh becomes Justice Kavanaugh. So I only have 2 more minutes. I know I stand between you and lunch. I'd be happy to talk with any of you afterwards with any questions you have. Thank you so much for your time and attention.
We want to thank Lisa very much for the presentation. It certainly was a long but very, very quick and fact-filled hour and a half. So thank you very much. I don't know if there are any questions. You're certainly welcome to ask them. If not, the next activity is lunch for the legislative and service awards. So, any questions? Yes, sir.
I'm not an expert in the law, so forgive my ignorance, but is the Supreme Court doing what it's supposed to be doing as defined by the Constitution? Right? The justices seem to be always having these 5 to 4. I know a lot of them are the boring cases, but why isn't the law more clear? Why is there such a, is their job to be social gerrymandering themselves, or is that something that Congress is supposed to do and they're supposed to rule on that, on whether it's constitutional or not? I'm trying to figure out what is the real role, and are they actually doing it regardless of who is in there at this time?
So that is the kind of question that I wasn't going to say someone could write a book about, that thousands of books have been written on. I will say, so I'll give you a couple very quick answers. I often carry a Constitution and I shake it. This is my pocket Constitution. The Constitution is really, really short. So it's invariable that there's so many holes and so many gaps that have to be left in there. So it is sort of, and then, these people that say we can know what the justices thought or the founders thought in the 1870s, 1600s, who knows? Maybe we can, maybe we can't. So that's one thing. I think another question that you're sort of getting at is, are the justices just politicians in robes? Is there actual law, or is it just sort of all what people want it to be? I went to the University of Wisconsin for law school, and the theory of the school was sort of was legal realism, and that was the whole point of it, was that there is no such thing as law. That law is just what the judges sort of want it to be, that words are, you can interpret it and do whatever you like with them. So there's all these ideas that swim around, and people can have very strong feelings on them. Being a conservative, being a liberal, being an originalist, being a living Constitution person, and there's more. And I guess the point of democracy is that we still should be able to decide those things. Like, people have different answers, and I certainly can't. In the end, this is your opinion. You can decide your opinion on those things, because I don't think it's knowable what, and we'll never agree on it anyway. So I feel like that's kind of a cynical answer, but it's my best answer. And like I said, there's tons of people who've written more long, thoughtful books on those questions, which we should always be asking ourselves.
Well, is there a safety valve? The fact that the states can get together and overrule, I guess, that safety valve, that if you get enough cultural impact to get the majority of the states to overrule it, they have the ability to take that action.
Yeah, absolutely. The Constitution can be amended. It's been amended a few times, not very recently, but absolutely. And, one of the stories I like to tell, too, is that the court, most of the time, the court is not interpreting the Constitution. Much of the time, it's interpreting federal statutes. One of the things I like to talk about is the fact that the very first thing that President Obama did, the very first thing he did when he took office, was he signed a law called the Lilly Ledbetter Fair Pay Act. The Supreme Court had decided a case involving a woman named Lilly Ledbetter, which basically made it harder for people to bring pay-related cases if they didn't know about them in enough time. And the Supreme Court had ruled that way, and Congress and President Obama took care of that in a second. Another thing that the Supreme Court did that was much annoying to Congress was all the stuff on the ADA, the Americans with Disabilities Act. The Supreme Court had narrowed the ADA. I was working at the National School Boards Association when Bush was leaving office, and we were told, under no uncertain terms, you will tell the Bush administration what you want, because we are pushing these changes through before Obama comes. And so the Congress overhauled the Americans with Disabilities Act as a result of a bunch of Supreme Court decisions that a Republican Congress thought went too far to the right. So there are some checks on the Supreme Court, but they're limited. They're few. And we lost a big one, I think, in some ways, in losing those 60 votes. Because before, to get a nominee through, you had to have some of the other party go along with it. And now you kind of don't. So, yeah, but you're right, there's a safety valve. Absolutely. Go ahead.
Thank you. Thanks for the presentation. I see from, and great information for all of us, your background and your group, you have a diverse.
I do.
And the last session that I was in the same room had to do with a short-term rental issue.
Yes.
Where there's a conflict, or at least some conflict between the state ideas about what to do about a situation, and maybe some of the local ideas. So I guess the question for you, from where you sit, is based upon your groups that you work for, I'm assuming you're advocating on issues where there's commonality of interest. Do you see any trends in how states are relating to local government and what those friction points might be?
Oh, boy. That's a really good question, and I would say a big question. More of what I deal with is the relationship between federal and state and local government versus the state to local government relationship. But what I would say, like going throughout the country and just hearing other people talk, the preemption appears to be a big issue. State legislatures being more aggressive against local governments, taking a position not necessarily in their favor. A lot of, I was just at the league directors meeting with Ken. A lot of culture wars issues, trying to resolve in the states, funding the haves, the have-nots. That's a hard question for me to answer because, like I said, mostly I deal with federal government's relationship to local governments rather than the state and local government's inability to get along, though it's, of course, a big issue as well.
Go ahead.
Especially since you mentioned both constitutional amendments and the Lilly Ledbetter Act, and I know it's controversial, so you can't give a hard pass, it's legal as it depends. But if, say, Virginia does the final ratification for the ERA, what do you think would happen with the sunset clause in the Constitution?
Oh, man, I have to admit, you know more about the topic than I do. I have not followed, and am not very well versed at all in what would happen or what it takes to sort of ratify. I just know that there's a process and that we haven't gotten close to it anytime soon. So I'm sorry I can't give you a good answer to that.
So Illinois just did ratifications with one state.
One state.
But there was a sunset clause.
Okay.
There's debate whether or not that would be constitutional or not because it's not prescribed in the Constitution.
Yeah, I don't know.
Okay, thank you very much.
Enjoy your lunch.